Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. We talk a lot on this podcast about how the False Claims Act is enforced, and the various ways that companies can get into False Claims Act trouble is a lot of those. But there's a very practical side to FCA enforcement that to me is just as important. It could be more important, and that's working with the Justice Department. DOJ attorneys, they have way more power than any other civil litigants attorneys. If they don't like your client, they can make things really, really bad. They can push for catastrophic things early in investigations. For example, they can ask agencies to suspend payments or suspend participation in whatever program is at issue. That's a really, really bad thing. Or on the other hand, if DOJ attorneys are sympathetic to your client, they can make things really good. They can cut investigations short, they can give you certain assurances, and they can even affirmatively dismiss a qui tam if they want to. So working well with DOJ attorneys is a really important concept, and that's what we're going to talk about today on the podcast, because it is something that sometimes lawyers are really bad at. I think it's a skill, and it's something where if you have a DOJ experience, you sort of understand what are the good ways to work with DOJ and what are the bad ways to work with DOJ. And that's why it's great to have people on your team who have that experience. And so today, joining us to talk about this is my fresh out of DOJ colleague, Todd G. So Todd recently joined Husch Blackwell following a long, distinguished career in the federal government. Todd was formerly the chief counsel at the U.S. House Homeland Security Committee. He was an AUSA in the District of Columbia. He was the deputy chief of Maine Justice's Public Integrity Section, which tackles the nation's biggest public corruption cases. And then he was the presidentially appointed Senate-confirmed U.S. Attorney for the Southern District of Mississippi. So, Todd, I am firmly entrenched in the Deep South, and I'm thrilled to have another Southerner to battle all these lawyers in the firm with these, funny accents. And so, Todd, I'm thrilled that you're with us here at Husch Blackwell. I think our clients are going to benefit from you. And right now, I'm thrilled that you're joining the podcast to tell our listeners a little bit about how the Justice Department works.
Thanks for having me, Jonathan. It's great to be here. I've really enjoyed joining the firm and using some of the experiences that I've had at the Department of Justice to help clients get the best possible outcome when they're dealing with the department or other federal agencies. And as a Southerner, I'm stuck here in Washington, D.C. instead of back home down south. Here at Husch Blackwell's office here, I'm really glad to be here, but it's nice to always have another person like you to get to chat with about these kind of issues.
That's right, Todd. So let's start with a caveat. So you just finished a term as U.S. Attorney, and I'm pretty sure your office didn't magically wrap up all of their FCA cases right before you left. So surely there's some stuff lingering, and I don't want our listeners to think that you're talking about specific investigations or specific cases that may violate your local rules. Not so sure about that. So let's start with this caveat. We're talking generally about how FCA investigations and cases work, how DOJ generally works, and not any particular case. Is that fair?
Absolutely. Thanks for that caveat. I agree.
Todd, let's start by talking about how DOJ works internally. One thing I think most people don't fully understand is the relationship between line-level attorneys and DOJ supervisors. I've said several times on this podcast that AUSAs have a tremendous amount of autonomy, and that's true. But they do still answer to people, usually a deputy chief and a first assistant and a U.S. attorney, him or herself. And so, Todd, you've worked in a bunch of these roles. Why don't you tell our listeners about how line-level DOJ attorneys work with supervisors, especially when it comes to FCA matters?
Well, let me start by saying I can't agree enough with you, Jonathan, on the basic point, though, that an AUSA or a Maine Justice attorney, if it's a Maine Justice only case, just an enormous amount of power and authority. And I don't think it can be emphasized enough that it's really important for clients to have an attorney that understands how to work well with line prosecutors or line civil attorneys. Because if you don't have an attorney that can do that, you are not in a position to get the highest probability of a good outcome. But in terms of supervision, I think first, look, I've been an AUSA, I've been a Maine Justice attorney, a Maine Justice supervisor, and then a U.S. attorney. And so I will sort of break that down for a second because I do think it matters. The amount of supervision between a line attorney and their supervisors, it really depends first on, is it an AUSA on the case or is it a main justice attorney, or is it both? I think it's really important for opposing counsel to try to figure out, if at all possible, what degree of main justice involvement there is in a matter. It's important to figure out, is main justice fully partnered in this case? So in an FCA realm, is the civil division fully partnered with the U.S. Attorney's Office? There's a civil attorney that's working on the case on a daily basis, helping out. Or on the criminal side, some criminal component like the public integrity section or the fraud section, fully helping out. Is it monitored? That's sort of the next tier down, where, the AUSA is mostly doing the case, but they kind of have to fill main justice in a little bit more often. That's a little more common in, say, like the national security sphere, where NSD monitors a lot of cases, but doesn't necessarily partner on as many. And then there's delegated. The AUSA is just doing the whole case. Maybe there's some box that's got to be checked from time to time with main justice, but not always. It's really important to figure that out as opposing counsel, because if main justice is partnered or highly involved in some way, that's going to affect the supervision and who's the deciders a lot. In the FCA space specifically, I think that an AUSA handling an FCA case has a lot of authority. There's two big decision points where supervision is going to come in. That's a CID and a settlement. And those are the places to really focus on if you're a supervisor at DOJ, but also if you're opposing counsel trying to hit one of those decision points is, when a CID is getting issued and when settlement's being discussed.
Todd, another critical skill in this job is just knowing how to work with DOJ attorneys, knowing what their goals are, why they're doing the things they're doing, how to get good results. To me, that's a bit of an art. There's not a book and you can study it and then recreate what it is that we do. So I think it's a bit of an art. The best defense attorneys that I worked with at DOJ, they made me want to help their clients. They were great advocates, but they did so in a way that didn't make anything seem adversarial. From your vantage point, Todd, in your years as a line DOJ attorney, what are your tips for working with line-level DOJ attorneys?
So some of them I think are personal and some I think are sort of actual technique-based. Look, on the personal level, there's no need to be a jerk. I think that so often, because we're all litigants and there's this V between us, that we let that leak into our personal interactions. And like it or not, that has an impact on a line attorney at DOJ or I think any federal agency. If you're a jerk, that line attorney is going to be a lot more willing to work till 2, 3, 4 in the morning building that case because you were a jerk. So always as defense counsel, don't give that AUSA the extra energy for the midnight oil by being a jerk on a personal level. You can litigate for your client, you can argue for your client, but you don't have to make it personal. I had some cases, as a deputy chief at Public Integrity, you have your own cases and you also supervise folks. And also as an AUSA in DC, that some of these cases were incredibly challenging, sensitive cases, sometimes with a lot of media attention. And the best attorneys were ones that knew that line between arguing for their client and just being a jerk. And sometimes it's as simple as making it very clear to the AUSA, look, like, if I were in your shoes, I understand that that's what you would want me to do, but my client just won't agree to that. And sometimes that slight separation between, look, I hear you about maybe this is being reasonable, but my client's not going to let me do that, creates that kind of human element that sometimes you need to keep that relationship going to get the best for your client later on. I think in terms of technique, tell your story. Obviously, sometimes you just got a client who is 100% guilty. They did it. They did the fraud. They planned it from day one. They did the murder from day one, whatever. Planned the whole thing. But often that's not the case. There's some shade, some context to what happened. Maybe they really did do the crime on purpose, but there was some context for why they did it. Or maybe in your view, they lack the intent, but made the false statement. So tell your story. I think in the violent crime context, we would often see the situation where the defense attorney is waiting till the last minute to sort of spring the surprise witness at trial. You see that in violent crime. I experienced that in a murder case once where my star witness was somebody who saw the murder out the window. We get to trial and the defense whipped somebody out who saw the murder out of a different window. We had, never heard of that witness before they took the stand at the trial. It didn't hold up well under cross-examination and we still got the person guilty. But, that kind of thing happens in some cases. But in the white collar world, in, say, the FCA world, there's going to be very few surprises by the time the case is advanced. So if, as defense counsel, you can tell your story early on, try to help the AUSA or the DOJ attorney understand the context of what was happening. Try to help them, and examples of that. I mean, like a couple weeks ago, Delta just had a big FCA settlement with DOJ related to PPP fraud down in your neck of the woods in Georgia, Jonathan. And I promise you, I don't have any personal knowledge, but I promise you as part of that case, a big part of it was the attorneys for Delta trying to make sure that DOJ understood everything that Delta executives and employees were struggling with during the pandemic just to stay afloat. And that kind of context matters. So try to help with the context. Try to help with the defenses. If you've got a defense that's either a legal defense or maybe just a level of defense in public corruption, it's not an actual legal defense, but often one of the defenses is friendship. You can still bribe someone who's your friend, but if the public official and the person trying to bribe them, they're very, very close friends, that may be a case that isn't going to go to trial or is going to get a better deal earlier on. So be super advocates for your client on explaining that friendship. By the time this thing, if it gets really closer to trial, the government's going to know all this anyway. So don't try to hold your cards overly much. Try to tell your story of what you think happened, what the defenses were, what the context was. There's no need to hide that in general, maybe sometimes, but most of the time, be more upfront with the AUSAs. I think defense counsel sometimes are unwilling to do that, usually because the AUSA is not sharing a lot of information with them. And I think particularly defense counsel that have never been at DOJ, they get very frustrated by that the reality is for a whole variety of legal reasons, policy reasons, et cetera, DOJ may not be telling you very much, but that doesn't necessarily mean that you don't want to tell your story back to DOJ. That may help you get the best resolution for your client.
Thanks, Todd. Yeah, so I love no need to be a jerk. That should just be like a PowerPoint slide that we put on for our brand new white collar associates, because really, no need to be a jerk. When you're at DOJ, people really do not, they're rarely jerks to you. My first civil litigation case, I was local counsel here in Georgia. After leaving DOJ, my first civil litigation, I was stunned at how opposing counsel was name calling and everything. So you do get sort of insulated from how a lot of lawyers talk to each other when you're at DOJ. But look, there's a reason for that. In DOJ world, you better be super confident in your ability to win at trial, and you better have your clients okay with all of this if you're going to be a jerk from the start. AUSAs, they just have way too much autonomy for you to risk getting on their bad side. And I don't think that you need to do that to get a good result for your client. Like I said at the top, you can have AUSAs who can push for payment suspensions, or they can push to dismiss your key and make all your problems go away. Like, there's just too much autonomy for you to be a jerk to them. So that's point number one. Don't be a jerk. I like that. So Todd, but a lot of times, even if you do the best job you can, you're not a jerk, you put your client in the best position possible, a lot of times you're still going to arrive at a best case scenario that your clients don't like. They're not going to like what DOJ is offering them, be it a plea or a big FCA settlement with intentions of a press release to follow, as always. And they want to know, what else can we do? One option there that I explore with clients is going over the line attorney's head to meet with a supervisor. Sometimes it's a chief, sometimes a U.S. attorney, depends on the situation. So me personally, I was a reasonable AUSA, so that rarely happened to me, but I do remember once where I liked the way that the defense attorney did it. And I remember once where I did not like the way that the defense attorney did it. So Todd, close us out by talking about requests to meet with a supervisor. How can we do that without totally torching our relationship with the line attorney? And what's the best way to advocate for our clients with a DOJ supervisor? In my experience, U.S. attorneys, they're probably going to default to taking the AUSA's side more often than not, unless you give them a good reason. So how can defense attorneys make those supervisor meetings successful?
So the first is a basic rule that I encourage defense counsel to never, never, never break, which is do not appeal above the line attorney's level without telling them that you are going to. Again, because I agree with you, the line attorney is going to get a lot of deference, whatever they're recommending. But in general, more than likely, that's what DOJ is going to continue doing. And the last thing you want to do is appeal that line attorney. They find out about it from their supervisor. And boy, you have really given them a reason to burn the midnight oil on your client's case moving forward. So always tell them, And you don't necessarily have to tell them how you're going to do it or at what level. Look, if you're going to appeal it to a super high level at DOJ, you don't necessarily have to tell them that, but tell them that you're going to. And I think you can do it in a respectful way. It can be as simple as, you've been really great to work with. We appreciate the cooperation we've had to this point, but I've consulted with my client. It's always safe to put it on your client. Consult with my client, and we just kind of think that a different outcome is still appropriate here. And we're going to appeal that up the chain. Hope you can understand that. And I think that most AUSAs, particularly sophisticated AUSAs that have been doing white collar work for a while, and certainly main justice attorneys, where appeals are much more common than in a U.S. attorney's office, know that it's going to happen. So always tell them and do it in a respectful way. But look, most folks, certainly in main justice, appeals are very common. And in U.S. attorney's office, it's relatively common. Next thing, make sure for clients out there that, look, there are many great people that can communicate with DOJ that didn't serve at DOJ. There are a lot of great counsel out there that didn't. So I don't want to be exclusive. But that said, in general, I think you're better off with an attorney who understands DOJ in some capacity or understands the government agency that they're doing in some capacity. I think that sometimes there's a belief that that means you want an attorney who's from that office. That's not always necessarily the case. You know, sometimes you can hire an AUSA that's from that office, but there's a backstory on why they left. And you're buying all that baggage when now they're in a room with the first assistant or the criminal chief or the U.S. attorney, however much you're peeling it up. So sometimes it's good to have somebody from the office, but I think in general, you want someone that understands DOJ and understands it at that level. So same sort of thing. Look, if you are appealing to the assistant attorney general's office, the deputy attorney general's office, some main justice level component, it's important to have someone that understands main justice. And that may not mean a defense attorney who was a line level AUSA in some district a long way from Washington. Make sure you've got an attorney that understands DOJ and understands at the level that you are needing to appeal at. And often that means someone that has that experience. And then look, in terms of the meeting, for counsel out there, first off, don't be shocked. The line attorney is almost always going to be in the meeting. I can't tell you how many appeal meetings I've been at where either when I was a supervisor or when I was U.S. attorney, where less experienced defense attorneys walk in the room to do their appeal. And you can tell that they're shocked that the line attorney is in the room. The line attorney, not always, but most of the time, they're going to get included even at a much higher level of appeal, at the very least, just to hear what the arguments are. So don't be surprised when the line attorney is there. And I think in those meetings, it's always important to, don't demean the AUSA, even if they're not in the meeting, and don't demean the agents that did the investigation. You can disagree with their version of how they perceive the facts or disagree with what the facts are. But generally speaking, attacking the AUSA, attacking the agent, unless you've got one of those rare cases where you actually have a good argument of selective prosecution or politicization, in general, that is a bad idea. And then focus on explaining context. Explain what was going on with your client at the time this happened. Explain the context around damaging documents, damaging witnesses. Context is just always so important. And I think that context is something that sometimes line AUSAs or line attorneys are going to fail to focus on because they're so buried in the spreadsheets, the witness statements, et cetera. And that's your best shot when you're on appeal, is to focus on the context, because you got a supervisor who knows a little bit about the case or a U.S. attorney that knows a little bit about the case, but you're appealing to their common sense, and context is common sense. I think that is the key thing to hit in an appeal meeting. And then defenses, because again, sometimes there will be times where that AUSA goes, just from day one, they're like, the friendship defense, it's not really a good defense to bribery, or the materiality defense, I don't really think it's going to be a good defense here to false claims. But when you're in that meeting with that U.S. attorney and you really focus on why you think there was no materiality in this False Claims Act context, or why you think that there's something that rebuts the elements of the crime or the claim on the civil side, sometimes, again, a supervisor is going to hear that, and then they're going to have more questions for that AUSA. And so I think context and defenses and really explaining them in a common sense way. Don't get buried in a ton of documents when you're in the appeal meeting. Context and defenses. And then, also just be prepared. I've been in very few appeal meetings where either they were appealing to me or they were appealing above me, where you got much out of it. Don't expect a lot of Q&A. You are not going to be able to ask the assistant attorney general, what are you guys focused on here? They're not going to answer. Don't expect a lot of Q&A. Don't expect a lot of exchange. A lot of appeal meetings that I've been in, the defense attorney gave their spiel, and it basically ended right after that with the person in charge saying, thank you so much. This is very helpful. We're going to be talking and we'll get back with you. Don't expect to get a lot of exchange, and don't be upset that you're not getting a lot of exchange, because that's a good way to have a good appeal meeting end badly when you display frustration that you're not seeing anything from across the table. Because DOJ, at least if they're experienced, is pretty rarely going to give you much feedback. And then, I'll add follow up. Until you get an answer, follow up. Send that email. If you actually got in front of a senior DOJ official, email his or her chief of staff. If you got in front of the U.S. attorney, email the FAUSA, email the crim chief until you get an answer. Now, you're often going to get the answer from the line AUSA. When the line AUSA comes back and says, hey, we're proceeding, it is usually a bad idea to then go back to the top again. Accept the answer when it comes from the line AUSA as a result of the appeal. But till you get that answer, follow up, because sometimes these kinds of decisions, especially when it's being made by a busy U.S. attorney, a busy senior main justice official, it may take a long time. And maybe behind the scenes, a long time's good for you because they're asking a lot of questions. I had times when appeals were made to me as U.S. attorney, and I asked a lot of questions afterwards, and that takes a while. So don't feel like a long period is bad for you. But I don't think anybody's usually offended if you follow up with, hey, want to make sure you're aware of these additional points, or just checking in to see if you needed anything else as you were considering the meeting that we had with you, that sort of thing. I think appealing is an extremely delicate thing. And the most important thing is what you started with, though, Jonathan, which is you want to do it in a respectful way with the line attorney, because their position is probably going to be what wins out. I will give one last practice point here, though, which is if you have a case where there is a main justice attorney partnered with an AUSA, and you feel that one side or the other is on your side more, whether it's at the line level or higher at the supervisory level. It is a delicate dance, but I think very good defense attorneys do a good job at splitting that difference of opinion, starting at the line level and then above. Again, maybe the main justice attorney, because they have lower caseloads, they've been able to focus more and they're a better appeal for you than the AUSA. Or alternatively, the AUSA you've tried a bunch of cases with, you can't get this main justice attorney to listen to you. You go and have a cup of coffee with the AUSA and you kind of cut a deal. Sometimes main justice attorneys or AUSAs, whichever side, will get a little upset when you talk to one side or the other. You got to be careful about that. But I've seen that difference split rather successfully sometimes, and split at an appeal level as well. Very rare that a senior DOJ official is going to do something different than what the U.S. attorney wants. But that's quite possible, particularly if it's a U.S. attorney who's not a very experienced U.S. attorney. It's a U.S. attorney who had never been a DOJ or not been a DOJ long. Maybe much more likely that the main justice officials are willing to overrule them. So sometimes you want to try to look for that split if main justice is involved in the case, or if you can get them involved in the case. Maybe it's just the U.S. attorney's office on the case, but you see some opportunity to get Maine interested, to get some component at Maine interested more. That can be very helpful. If you've got a False Claims Act case and it doesn't have a relator involved, and it seems like it's just the U.S. attorney's office, and you think that they're being unreasonable, try to see if you can get the civil fraud section to be involved.
Todd, those are phenomenal insights. I'm so happy that you walked us through all that. I think that you're spot on. Just in terms of the basics, I can't tell you how many times I hear about defense attorneys messing up the don't go over the line AUSA's head without telling them rule. That happened to me. I didn't like it. Didn't turn out well. The U.S. attorney took my side, and relationships were torched after that. That's far from the only time that happens. It happens just a ton, and it shouldn't. You laid out, Todd, the right way of doing it, which is fronting it with the line level attorney, saying, look, I feel strongly about this, especially when you're coming at it from some sort of a policy thing. Like you're saying, look, there's this thing in the Justice Manual that says this. I know for a fact other cases have been treated this way, the way that I'm asking you because of X. I just love the opportunity to talk to someone about this, because I don't know that you're properly crediting what it is that we're talking about here. The same thing if there's new guidance out there from leadership. President Trump put out the sub-regulatory guidance bar earlier this year. dissimilar to the Brand memo from the first Trump administration. And a lot of AUSAs just ignore that. And so if you're in a situation where you think, hey, this is soundly within President Trump's memo on sub-regulatory guidance, and the AUSA just says, well, tough, I feel strongly about what I'm doing. I think at that point, going up and saying, look, I just want someone else to weigh in on this from a policy matter. Is this something that the department should be doing? That's the right way of doing it. But knowing how to do that, Todd, is something that is really, really important. And so, Todd, I'm thrilled that you're now on our team because I think our clients are going to benefit from your perspectives here. I'm thrilled that you're with us. And Todd, just thank you for coming on the podcast and telling our listeners about DOJ. I think this was excellent.
Thanks for inviting me, Jonathan. This was a lot of fun.
So I want to close by talking about the stakes at play here. We talked in our last episode about how two pharmacies faced a potential $27 billion FCA judgment following trial. You may have also read about a pharmaceutical company's efforts to get an appellate court to reverse $1.6 billion judgment following a loss in an FCA trial. That happened last month, around the time we put our last episode out. But I fear people hear those stories and they say, that's just a rounding error for mega corporations. This has nothing to do with me. But that's not so. These issues may matter even more for the companies that legitimately have their very existence on the line. These issues are very real for health systems, physician groups, defense contractors, importers thinking about tariffs. For them, moving a decimal over a spot in your FCA judgment might be the difference between staying in business, paying your employees, and maybe folding up shop. And how you work with DOJ might just be the difference between those two outcomes. One example came out a couple of weeks ago. 2 people in South Dakota were indicted for government fraud, convicted, sent to prison, and only then did DOJ file a False Claims Act complaint, trying to get treble damages and penalties for things 2 people had already been convicted of. They ended up with an awful problem sitting in prison, turning into an even worse one, sitting in federal prison and now owing millions of dollars they didn't before. If DOJ doesn't like you, they can crush you, as those 2 guys in South Dakota found out. You've got to know how to work with DOJ to get just results. And that's what I hope we've offered a glimpse of in this episode. And that's what we're going to continue to talk about on this podcast. So I hope you enjoyed this conversation with Todd. There's more to come on this podcast, so keep listening to us however you listen to this one. Thanks for listening, and we'll see you next time.